Ladies and gentlemen, good morning. Dear Dr. Dannemann, dear Dr. Caffé, thank you very much for the nice introduction and the invitation to speak at your prestigious institute today. It's a pleasure for me, and in fact, my wife and I, we are in Rio for the first time, and we have done things that tourists usually do. Yesterday we visited Cristo and Pau Açúcar, but it's not only what tourists do. We feel so much at home that I yesterday bought a football jersey from Flamengo. So I'm really basically at home, you know. It's my pleasure today to talk about the Trade Secrets Directive of the European Union and a few aspects of it that have been transformed into German law. I know that you are familiar with the mechanism of legal harmonization in the European Union. The European Union enacts legislation in the form of directives and regulations. Regulations are immediately applicable in the member states, and regulations have to be transformed by the member states in order to achieve a harmonized legal system for the internal market, which is one of the most important goals of the European Union, as you of course know. No, I have to go back. Yeah, this is my agenda. A few words as an introduction, and then I will go into the regulation and the German law about trade secrets. Now, this is the basically the optics of a directive. They are being published in the official journal of the European Union, the purpose, as I said, of regulations and directives is to harmonize the law of the member states. And this is particularly important with regard to commercial law, of course, because we have companies that are active European-wide, and they don't want to have invisible borders, legal borders, basically. Also the trade secret law has to be harmonized. You know that trade secrets are a determining factor for competitiveness and innovation-related performance in the market, alongside with patents and other IP rights. Actually, in Germany, we have come a bit of a way to reach this point of view. Traditionally, trade secrets were regarded as a matter of unfair competition law. So the law used to be in the law against unfair competition, but the more modernized view is that trade secrets are actually something like intellectual property. And so this is reflected by the directive and also the nowadays the German trade secret law. The scope of the directive is the civil law. Criminal law is left to the member states. In the directive, we have a couple of regulatory instruments, of course, definitions, measures, procedures, and remedies for holders of trade secrets, and also very important, as you know, as trial lawyers, procedural safeguards to make sure that your trade secret stays a trade secret during litigation. I will start with a couple of definitions. Not surprisingly, ladies and gentlemen, a secret is something that is not generally known. Yes, we needed the directive, you know, to learn that. Also, it has to have commercial value because it is secret, and also the holder of the trade secret has to engage in reasonable steps to keep it secret. So you have to do something for it. You have to do an investment, if you like, to keep it a secret. What can be a trade secret? I mean, this is pretty obvious to you, of course. You can have product-related characteristics, know-how, like ingredients, recipes, the Coca-Cola formula, ladies and gentlemen, or the Guanada's secret, right? Thank you, thank you. Of course, research and development findings, construction drawings, components of complex machines and software, or other commercial information that you like to keep secret as a company. For example, your price calculations, your customer list, or even payroll information. The trade secret holder is by definition any person lawfully controlling the trade secret. And the infringer is a person that has unlawfully acquired or disclosed a trade secret. And then, as a third definition, we have the goods, infringing goods, that are goods, the design characteristics, functioning, production or process of marketing of which significantly benefits from trade secrets unlawfully acquired, used, or disclosed. Now, what is lawful acquisition? If we want to rule out unlawful behavior, we have in the first place to know what actually is the lawful behavior. What are you allowed to do? And this is what the directive tells us in Article 3. The acquisition of a trade secret shall be considered lawful when the trade secret is obtained by independent discovery or creation, by observation, study, disassembly of a product that has been made available to the market. So what we know as reverse engineering is a lawful means to obtain a trade secret. Also, if workers exercise their rights, like union rights, this is lawful behavior. And any other practice, and this is like a very general concept of justification, any practice which under the circumstances of each individual case is in conformity with honest commercial practices, right? There's room for the judiciary to determine what that actually means, but we have the most important aspects are in the letters A to B, I suppose. Now, unlawful acquisition, use, and disclosure of trade secrets, Article 4, subsection 2 to 4 of the directive. The acquisition of a trade secret without the consent of the secret holder. So you see, the consent of the secret holder, of course, as we know in IP law in general, is the best justification to make use of intellectual property. So if you don't have the consent of the trade secret holder, the acquisition of a trade secret shall be considered unlawful whenever carried out by unauthorized access to documents, objects, and so on, from which the trade secret can be deduced. Any other conduct which under the circumstances is considered contrary to honest commercial practices. There again, this general clause that leaves room for the development of the law by the courts. And also, if you use or disclose a trade secret, the use or the disclosure is considered unlawful whenever carried out after having acquired the trade secret unlawfully, but also, and this is quite interesting, if you are in breach of a confidentiality agreement. So you can have an agreement to keep something a secret, to keep silent, and if you violate that agreement, then you will be in violation of the trade secret law. So the contractual obligation is, if you will, actually enhanced or improved or hasn't getting additional force by the trade secret law. However, it is not only that people in bad faith can violate the trade secret law. We have also a standard of negligence built in, because the acquisition of a trade secret shall also be considered unlawful whenever the person knew or ought under the circumstances to have known that the trade secret had been obtained directly or indirectly from an unlawful source. So we have, this is really quite important, the standard of negligence that you have to obey. As I will come to later, for negligent behavior, we have a liability privilege, like a lighter standard as it comes when it comes to damages, but still, negligent behavior can lead to a violation of trade secret law. Now I come actually to the measures, procedures, and remedies for holders of trade secrets, because the regulation, the directive stipulates that member states shall ensure, so you see the concept of harmonization, that it's addressed to the member states, they shall ensure that the competent judicial authorities may, at the request of the trade secret holder, order provisional and precautionary measures against the alleged infringer, and that is a variety of measures that you are familiar with from your usual IP litigation: cessation, prohibition of production, offering, and so on of the infringing good, seizure or delivery up of the suspected infringing goods. So the member states have to make sure that the infringer stops and has to bear the consequences as to the products on the market. The member states also ensure that the courts have the adequate procedural means to act on trade secret violation, to the cessation of the use of the trade secret, also to prohibit the production, offering, placing on the market, and so on of the infringing product. You can seize infringing goods, and to make sure that the infringement is accordingly prohibited and the consequences of the infringement are being put away. Now, the courts have some room to decide on the measures that are appropriate in each individual case. And so Article 12 of the directive tells us that the courts of the member states shall pay attention to a couple of aspects to make sure that to make sure that the measures being taken that they are according to the principle of proportionality. This is, as you know, a very important legal concept under the German constitution, also under the Charter of European Union fundamental laws. And I'm quite sure that also the Brazilian constitution probably provides for something like that, that acts of the state have to be proportional as to cause and effect with regard to the citizen or the company that is affected by the measure. And if a state court orders cessation or prohibition of something, then the court has to make sure that this complies with the principle of proportionality. And the aspects that have to be taken into account are shown in Article 13 of the directive. The value of the trade secret has to be taken into account. A very valuable trade secret probably justifies tougher sanctions if violated than only a not so very important trade secret. Also, the measures that the trade secret holder has taken to protect the trade secret. If the trade secret holder himself is negligent, there might be less justification for very strict reaction. Also, the conduct of the infringer has to be taken into account. You know, the bad guy, the really bad guy, maybe will be treated a little bit differently than somebody who had only been in negligent violation of the trade law. The impact of the unlawful use, so what has actually been done with the trade secret as with regards to the damage on the side of the trade secret holder, but also you know, what the consequences of the use on the side of the infringer can be taken into account. Legitimate interests of third parties may be considered. Also the public interests, and finally the fundamental rights, the constitutional fundamental rights have to be taken into account. Of course, if the trade secret holder decides that he is no longer interested in, you know, pursuing the infringer, then the court has to stop the measures on account and by the trade secret holder. This is a civil action, and if the rights holder, you know, stops the proceedings, then there's no necessity to keep sanctions in place. Then, very important, of course, damages can be a sanction, Article 14 of the directive. But this is the point I mentioned earlier. If you are only in negligent violation of the trade secret, then you will have a privilege when it comes to damages put down in Article 14, subsection 1. Only damages appropriate to the actual prejudice suffered as a result of the unlawful acquisition. Okay, and finally, the directive also provides for some options that the member states can make use of or leave it. This is also a part of the concept of harmonization. You can have obligatory harmonization that really tells the member states what to do in every respect. On the other hand, you can have the directive can open up options that the member states may pursue but don't have to pursue. And this option concerns the disclosure of names and addresses of manufacturers and so on. And you know from your IP litigation practice that it is very important to know, where the bad stuff comes from. You have to know what the source is. So, and this is also in German IP law. It's basically self-explanatory that you need that. So the German legislator did not hesitate and also made use of this option. So we in Germany, as a trade secret holder, you have the right against the infringer to know, the sources of the product that violates the trade secret. Okay. Quite important to know that we have some exceptions, Article 5 of the directive, because the member states shall ensure that an application for the measures I just spoke about is dismissed when the acquisition, use, or disclosure of the trade secret was carried out in specific situations. First of all, if the alleged infringer made use of his right to freedom of expression and information. This is a specific reference to a very important constitutional fundamental right, the freedom of expression, that can cover, behavior that otherwise would be considered as trade secret law violation. Also very important, the whistleblower exception, because the revealing of misconduct, wrongdoing, or illegal activity can also be excused, even if a trade secret is being disclosed. Then we have another workers' union exception. I think that's not that important, but of course has to be provided for. And then we have a general clause that you have to check whether the disclosure of the trade secret was in pursuit of a legitimate interest recognized by union or national law. So this again is a very broad provision that just makes sure that if there are justifications, well, for example, coming from fundamental rights, constitutional rights, or other situations, that they can be taken into account. Now, short remarks to some more procedural aspects. The burden of proof. If you sue as a plaintiff, then you have to prove that you actually own the trade secret. You remember the definition I told you in the beginning. It has to be secret information, it has to have commercial value, and you have to show the court that you made reasonable effort to keep it a secret. And of course, you have to show the infringement that the defendant shall be responsible for. And if you go about in your complaint and you try to describe actually what the infringement is, and it is required that you describe your trade secret in the first place, as I said before, there is a danger that you actually disclose your trade secret I mean, it's mandatory that you disclose your trade secret to the court, because the court has to decide whether it actually is a trade secret. But, you know, in Germany, for example, and all over Europe, the court hearings are being held in public. This is a fundamental constitutional procedural right. So if an interested competitor of the two parties involved in the litigation is sitting in the back of the courtroom, he will gladly take notes about the trade secret. And this leads to the, how shall I say, not very satisfactory situation that you actually have to disclose your trade secret during trial, meaning if you don't do that, either you disclose the either you lose the trade secret, or if you don't disclose it to the court, then you lose the trial, right? This is a catch-22 situation, and we have to deal with that. The legislature has to deal with that. And the solution, of course, is that you have to provide for procedural safeguards that make sure that a trade secret actually stays a trade secret during litigation. And this is the final part of my short speech today, that I want to show you how German courts, or how the German law enables German courts to reach that goal. And of course, this is also provided for in the directive, but I rather now turn to or have also an eye on the German trade secret regulation, because this is what concerns me as a judge. You know, I have to make sure that that the trade secret stays one. The court may order confidentiality relating to certain information that is prima facie, so on the first view, deemed a trade secret. Of course, this is a problem, because when the trial starts, the question whether something is a trade secret still has to be determined. To make sure that we don't have an accident during litigation, you have to, look at the facts, and, by rule of thumb, you have to estimate whether this probably is a trade secret. We should engage in procedural safeguards. Of course, the trade secret holder has to apply for that protection. And he can do that as soon as the civil action is pending. And then the court has to consider whether the interest of the trade secret holder actually outweighs the right to be heard. And this is another very important constitutional right in Germany and the European Union. As I said before, not only that court hearings are public, but also, oh, sorry, I forgot to go, but also that this is a provision from the German Grundgesetz, the German Constitution. In the courts, every person shall be entitled to a hearing in accordance with law, meaning that as a party to a proceeding, you have the right to know what is actually going on, right? As a plaintiff, you have a right to know what the court does. You have a right to know what the defendant is actually arguing, and the other way around. And this is the situation we are talking about here, because as a defendant, I have to know what actually the charge is to be able to defend myself, right? So if something is kept secret, if I'm accused of violating a secret and nobody tells me what the secret is, then I actually can't defend myself, right? This is the problem of the what we would call Grundrecht auf rechtliches Gehör, the right to be heard, to know what is going on in the trial. And this is also reflected in the Charter of Fundamental Rights of the European Union. You have the right to a fair and public hearing. And even in the convention, European Convention on Human Rights, basically the same provision. This is the older provision, right? The Charter of the Fundamental Rights of the European Union was enacted many, many years after the Strasbourg Convention. Of course, you know about the Strasbourg Court of Human Rights. So this is the problem that we are talking about here when enacting procedural safeguards to make sure that a secret stays a secret. I would like to point out that in German law, this whole trade secret law, according to the directive, started with a specific trade secret law, Geschäftsgeheimnisgesetz. This was enacted to transform the directive. But in the meantime, we have noticed, I mean, the judges knew that before, but even the legislature has noticed now that there is a demand for procedural safeguards for secrets, not only in trials specifically concerning trade secrets, according to the trade secret law, but also in any civil litigation. It can be possible that during arguing your case as a plaintiff or defending your actions as a defendant, you have to relate to trade secrets of yours in one way or the other. And that is why first in the Patent Act in Germany, but in the meantime, even in the General Code of Civil Procedure, we have a reference to the trade secret law, meaning that German courts can now enact procedural safeguards, not only in proceedings that involve actions under the trade secret law, the specific law in transformation of the directive, but in any civil litigation, the courts can now make sure that can enact these measures to protect a secret from being disclosed. This is really, in my view, a huge progress, and this has removed a serious flaw in the former German law. We really have improved the situation here. Now, what happens if the court orders confidentiality? The parties, their lawyers, witnesses, experts, and any other persons participating in legal proceedings relating to the unlawful acquisition and so on of a trade secret are not permitted to use or disclose any trade secret which have been identified as confidential by the court. This is the obligation that results from an order of confidentiality. What happens if a party or any person breaches that obligation? There can be a disciplinary fine up to 100,000 euros, or, this is what I like the most, confinement for contempt of court, ladies and gentlemen. We know that from US legal theories, we actually don't have that in that extent in Germany, but still, you can be put in prison, if you don't comply with court orders. But as a matter of proportionality, I must say, we would start with a fine first, right? Okay, I'm sad to say that. But almost more importantly, you are exposed to civil liability under the actions that I have explained before. The claims that can arise from trade secret law are applicable in these situations. So this is really a powerful instrument because the court basically, if it orders confidentiality, it installs a whole, the whole regime of trade secret measures and sanctions upon the parties part of the proceeding. This is really a powerful tool. Also, the access to court documents can be restricted. With the effect that the parties or third parties well, that the access is limited to a limited number of trustworthy persons, including at least one natural person from each party and the respective lawyers or other representatives. So as a lawyer, you have to identify the one most trustworthy person in your client's company, and that person then will be entitled to know the secret, but has to comply with the obligations of keeping it a secret. Sometimes we have the situation that third parties are applying for access to the files because they have related issues, they want to know what was going on. And obviously, they shall not know what the trade secret is about. So access of third parties is limited, and especially the trade secret has to be edited out, right? And I mean, you know, the procedural situation is that if you apply for this order of confidentiality, then you have to provide your claim in a full version and also in a redacted version where the trade secret is already, you know, how do you say, redacted out. And this is the material that, if it needs to be, third parties can have access to. Of course, if the court takes a decision and describes the trade secret in the decision, then this would have to be edited out by the court, obviously, before third parties get to know the decision. Very important also that the confidentiality obligation does not end with the court proceedings, obviously, but it continues to exist after the trial ends unless the court finds that there is no trade secret, right? In the beginning, you have this rule of thumb, well, that could be one. If you have the decision at the end that there is no trade secret, then there is no need to have this this measure of this order of confidentiality going on. Yeah, in a practical sense, I already said that the seeking party has to designate statements that contain trade secrets. So you really have to alert the court to the sections that are, you know, sensitive information. And also the seeking party, I already said that, has to provide copies of documents where the trade secrets have been edited out. This is, you know, to relieve the workload of the court. As to appeal, if the court denies a trade secret situation, then the party can appeal that. On the other hand, if confidentiality is granted, this stays on until the whole case is pending in the Court of Appeal, right? So things are kept together. There will be done no harm because we have the confidentiality order in place, and then the Court of Appeal can make its own judgment whether the court of first instance was actually right in, you know, in finding for a trade secret or not. Yes, and as to the confidentiality measures for court hearings, and this is my final slide, you are almost done. We have no in-camera hearing, meaning a hearing without the public in Germany. This has to do with the fundamental principle of publicity in court hearings and court actions. I stated before. This is a constitutional provision, so we cannot keep the public out, right? But you can exclude the general public and restrict access to a limited number of trustworthy persons, again, including at least one natural person from each party and the respective lawyers or other representative. And then also regarding the record or the court record or the court transcript, these court records can also be accessed only by the specific circle that I mentioned before, if it isn't redacted, right? I mean, the redacted court records are not problematic in that respect. So we have a great variety, or at least a quite powerful instrument to enact procedural safeguards during trade secret litigation or any other civil litigation. And we have quite meaningful sanctions if the trade secret or the obligation of confidentiality is violated. And so, as it is my job, ladies and gentlemen, I'm very content with this legal situation, and I would presume that the situation in former times where you either lose your trade secret or your trial, that is really a matter of the past, and we have powerful instruments to safeguard adequate confidentiality nowadays. Thank you very much.